Hey, I'm Adam Goldstein. I'm an attorney with the Student Press Law Center, and I wanted to give you an update on the latest in the Anthony Mazur situation. That's Flower Mound High School, or the IAmAnthony hashtag if you've been following that. To recap, if you don't know the story so far, Anthony Mazur was taking pictures at school events. He's a student, I should say that if you don't know that. And uploading those pictures to his Flickr page. And these are things like football games, volleyball games, that sort of thing. Parents and relatives could then buy full-size versions of the photos for a couple of bucks. Somebody who didn't like that they would have to pay a couple of bucks complained to the school, and the school attempted to punish Anthony, to suspend him, and they had all kinds of different theories for why, including, but not limited to, because they changed their explanation every 20 seconds, that these photos were district property, that the school owned the photographs because the school owned the camera. As they got informed very quickly by professional photographers everywhere, that's not how copyright law works. Ownership of the medium has nothing to do with ownership of the medium. The photographs are owned by whoever fixed them in a tangible medium of expression, which is a fancy way of saying the photographer, or Anthony in this case, right? Right. So that's what we know so far. The school eventually backed down. So what's happened now is that Anthony signed up for the yearbook class this year. Time passes, nothing happens, school says nothing until a little over a week before the start of the class. And then they send it around this document they want everyone to sign, and it's titled School Rules Regarding District Equipment. And when you read down to the end of the second graph, it's only one page, so it's the middle of the page, it tries to be a work-for-hire contract. A work-for-hire agreement is how, in the absence of an employment relationship, you would transfer by operation of law, essentially, the rights in the photographs you take to another party. And work-for-hire contracts are hard to create. So I'll link this document below. Now Anthony's being told if he doesn't sign this agreement, he's not allowed to participate in the yearbook. He's going to be administratively dropped from the yearbook class because since the district owns the computers in the yearbook room and he has to use the computers to upload stuff for the yearbook, he can't participate unless he agrees that the district gets to own everything he does. Which is ridiculous, for a lot of reasons. And I could make probably 15 videos explaining why, but I wanted to make this video to explain just a couple of the really big defects with this, and I'm sure I'll make a subsequent video because there's probably 15 or 20 reasons why this doesn't work. So let's get right into it. The big reason why this doesn't work, the big one why this might be a structure you couldn't use in a public high school, is that the agreement is coercive. If you look at what the requirements are to have a work-for-hire agreement, Title 17, Section 201, subsection E, actually says these agreements can't be involuntary. And you would think that might just mean like transfers through government seizures and stuff, but if you look at the House report accompanying 201E, and I'll link that too, it actually says that you need to determine if these agreements are obtained by covert coercion to make sure they're actually voluntary. So let's look at the circumstances here, okay? Let's look at the circumstances. We have Anthony, a student, signs up for a class and then is suddenly told, before he's allowed to actually enter the class, he has to agree to surrender his personal intellectual property as a condition of receiving the government benefit of the public education he's required to obtain. That seems coercive to me. That seems like not really two independent parties negotiating an intellectual property agreement. And in fact, you have to ask, could there ever be a relationship between a public high school student and an administration that isn't coercive? I'm not super sure you could. I mean, look at other areas of constitutional law, like look at the First Amendment and religion. There are these limitations on what administrators can say about religion to students in the course of their actual instruction, because the relationship between those administrators and students is inherently coercive. Students are required to be deferential, they're required to pay attention, and there's a desire to please, and so could you ever have a relationship between district administrators and students that isn't coercive in the context of a work-for-hire contract? I'm skeptical, but you certainly couldn't do it the way that Flower Mound did it. That's pretty clear. So that's defect number one, is that this is not actually a work-for-hire contract because it was obtained by means of coercion. Defect number two, is one that even the person who drafted this, assuming it was drafted by their lawyers, would know, which is lack of consideration. See, I say it that way because this agreement sort of has the look of a document that might have been drafted by a lawyer but was not drafted by a copyright lawyer. I mean, if you know me, you know that I specialize in copyright. That's my primary area of expertise. And I'm one of the few people in the country who focuses in on the relationship between students and institutions in copyright. So, what this looks like, this is like, it looks like a patient who had neurosurgery done by a podiatrist, if you know what I mean. It's like podiatrists being doctors, they know what they're doing, but not well enough to actually execute neurosurgery. And this is sort of the same thing here, where it sort of looks like the person who wrote it knew some of the words and occasionally got the order right, but didn't actually know how to hook it all up and make it work. So anyway, back to what I was saying before. What any attorney would know is a problem here is lack of consideration. Because if you look at work for hire provisions and you look at the Copyright Act, there's only 3 states of being. There's only 3 states of being that a person can be in. State number 1 is they can be an actual employee of the institution. State number 2 is they could be an independent contractor. And state number 3 is they're nothing. There's no relationship. They have to fit into one of these bins, because it's not the hokey pokey. You don't get to put them into this category when you want something and take them out, like Mazur does. It's another story. But, so students have to fit into one of these categories. So we know the district doesn't want them to be employees, because employees, they have to pay a minimum wage. We know they don't want that. And we know they don't want them to be nothing, because if they wanted them to be nothing, they wouldn't have circulated this document around. They wouldn't know anything, because students own their work if there's no relationship in that way. So then the district is trying to make them independent contractors. Well, independent contractors implies a contract, being contracted to do something, and contracts require consideration. Consideration, if you didn't go to law school, is something of value being transferred to turn a non-binding promise into a binding contract. It's the item that's being exchanged for the thing of value someone's trying to get. And there's no consideration in this contract. The students aren't getting anything. The only thing they're getting is access to a government benefit that's already paid for by the state that they were supposed to have access to before anyway. That's not consideration. You can't give consideration in a contract by giving somebody something to which they were already entitled. So this is not a contract, which means they're not independent contractors. You know what this is really? What this really looks like? The structure of this is extortion. It really is. I mean, think about it this way. Let's say I run the school, and I say, everybody come to my school. I wait for people to get there. They're lined up at the door. I say, wait a minute. Okay, you can come into my school, but if you want a chair, you know those chairs the state of Texas paid for? If you want to sit in a chair, give me your shoes. You don't have to have a chair. That's a benefit. That's a gratuity of the chair. No, it's not a benefit. It's a gratuity. This is something that the state paid for the purpose of benefiting students. And now the district is trying to use it as leverage to extort personal property from students. That's not consideration. It's also not exactly an involuntary contract. That's pretty coercive. So that's yet another reason why this is defective. And by the way, there's like a savings clause in this that says, well, if it's not a work made for hire, then the student agrees to assign it to us. Well, guess what? Assignments also require consideration. You have to give something to get something. That's how you make contracts. That's how you make things happen. So this is a hugely defective agreement. And you know, one more thing I should point out about this, although I could go on talking about it for like 4 or 5 hours about the legal defects with it, I want to point out there's no legitimate reason to do this. No other school in the country has felt the need to do this. For decades, we've managed to get through public education without doing this. This is the only reason I can think anyone would try to do this, is that the district is having a temper tantrum because they didn't get their way. Well, they're not going to get their way now, so look out for their temper tantrum next year, because certainly we're going to help Anthony oppose this. We're going to look for more local counsel to help him oppose it in more formal ways. And I have faith that all the organizations that have stepped up before are going to step up again and help Anthony oppose this. If you want to help, you can send me an email at agoldstein, AGOLDSTEIN @splc.org, and I will keep you posted.